Ready? Legal matter, exercise number 105, start. Since there was no appearance on behalf of the respondents, we requested Sri Santosh Krishnan to assist us as amicus curiae, and he readily assignment and ably assisted us by filing written submissions supporting the judgment of the High Court. The primary submission of the amicus curiae is that the state government does not have the legislative competence to make the impugned rule. Stop, next para. He argued that matters relating to prescription of conditions, methodology for verification, and even certification of fitness of vehicle under bracket section 56 read with the rule 62 bracket out, as well as the power to fix the age limit of a motor vehicle under bracket section 59 bracket out, fall within the province of the central government, and therefore the state government does not have the competence to make rules 174 under bracket 2 under bracket C. He would urge that a collateral challenge to the impugned order on the ground of competence is legally permissible. He drew our attention to rules made in other states to demonstrate that none of them have made a rule akin to Rule 174 Sub-Rule 2 Sub-Rule C that touches upon the fitness of a vehicle. Stop, next para. Section 83 is an enabling provision. It allows a permit holder to replace the vehicle covered under the transport permit. The right to replace the vehicle under a permit is subject to the permission of the authority. The right as well as the power to grant permission are subject to the condition that the vehicle to be replaced is of the same nature. These are open textual expressions used in the normal course to convey a meaning which the legislature would not have intended to be read in a pedantic manner. When the words in the section allow multiple interpretations, courts of law have developed the art and technique of finding the correct meaning by looking at the words in their context. This approach is beautifully expressed by Justice D. Chinnappa Reddy in the case of Reserve Bank of India versus Peerless General Finance Investment Cooperative Limited and others. Stop, next para. Interpretation must depend on the text and the context. They are the basis of interpretation. One may well say if the text is the texture, context is what gives the color. Neither can be ignored. Both are important. That interpretation is best which makes the textual interpretation match the contextual. A statute is best interpreted when we know why it was enacted. With this knowledge, the statute must be read first as a whole and then section by section, clause by clause, phrase by phrase, and word by word. If a statute is looked at in the context of its enactment with the glasses of the statute maker, provided by such context, its scheme, the sections, clauses, phrases, and words may take color and appear different than when the statute is looked at without the glasses provided by the context. With these glasses, we must look at the act as a whole and discover what each section, each clause, each phrase, and each word is meant and designed to say as to fit into the scheme of the entire act. No part of a statute and no word of a statute can be construed in isolation. Full stop. Thank you very much.